This morning, the state attorney suspended by Florida Governor Ron DeSantis over abortion plans to file a motion challenging that suspension. DeSantis removed Andrew Warren earlier this month for pledging not to prosecute crimes related to abortion and gender transition treatments for children. DeSantis, who seems to be weighing a 2024 presidential run, accused Warren of neglect of duty and incompetence. Warren, a twice elected Democrat, calls his ouster an abuse of power to overturn a free and fair election. Joining me now is the Hillsborough County State Attorney suspended by DeSantis, Andrew Warren. Sir, thank you so much for being with us. What action are you taking this morning?
Well, the governor's violated two laws. One, he's retaliated against me for speaking out against him in violation of my First Amendment rights. And he's abused the power that he has under the Florida Constitution to suspend an elected official. So we're fighting back to make sure that even though Ron DeSantis is governor, the First Amendment still has meaning. The Florida Constitution still has meaning, and elections still have meaning.
You're filing a motion in court, federal court, on what grounds exactly?
Well, there are two grounds. One is a First Amendment claim because he's violated my First Amendment rights. And the First Amendment applies to everybody. That's the beauty of it. That's why they put it up front in the Constitution, too. The second claim is called quo warranto, and it's basically just to have a court admit and show that what he's done abuses his authority under the Florida Constitution. He can't just suspend an election. He can't just throw out people's votes because he disagrees with something that I've said.
On the first point, you say free speech. What this is over is a pledge that you signed, and he would argue a promise that you made not to prosecute people who violate abortion laws in Florida. You signed a pledge with other prosecutors that says, quote, "We decline to use our office's resources to criminalize reproductive health decisions and commit to exercise our well-settled discretion and refrain from prosecuting those who seek." So you're saying that's speech, but he's saying you're telling people you're not going to do your job.
Well, let's be clear. First of all, that's a value statement that I signed on to, talking about that I believe that criminalizing healthcare decisions between women and their doctors is not something that we should be criminalizing. Second, that law, the 15-week abortion ban that was passed by the Florida legislature, has been held unconstitutional. So when I became state attorney, I put my hand on the Bible and I swore to uphold both the U.S. and the state constitutions. And that's what I'm doing. So I can't enforce an unconstitutional law, and no case has come before me yet. This isn't about anything that I've done. This is about what I've said.
If a case comes before you that violates a law that is deemed constitutional on abortion, will you prosecute it?
Well, we look at it the same way we look at every single one of the 50 to 60,000 cases that come to my office every year. We look at the law and we look at the facts, and then we make a decision on that case based on case-specific information.
If the 15-week ban ultimately is deemed constitutional based on the Florida state constitution, again, if someone violates that, would you prosecute?
Yeah, I mean, again, you're asking questions in a hypothetical. I said we have to evaluate the merits of each case. I'll tell you that even under current law, right, the 15-week ban is unconstitutional. But going back to the Roe standard in Florida of 24 weeks, there's a difference between someone who has an abortion at 24 weeks, and there's a question as to whether it was 23 weeks and 6 days or 24 weeks and 1 day, versus someone who has a back alley abortion at 35 weeks. So that's why we say we have to look at the facts of every specific case. You can't just say I'm always going to or I'm never going to in situations. That's not how prosecution works.
As a legal question, it's interesting. Are you saying that he would have the right to suspend you or remove you from your office if ultimately you did make that decision not to prosecute?
No, not at all. I mean, the Florida Constitution sets very limited parameters under which a governor can suspend an elected official. And what's happening here is he's trying to overturn a free and fair election. He's trying to throw out the votes of hundreds of thousands of Floridians. And he's trying to substitute his judgment for that of the voters who elected me. I mean, even my 8-year-old understands this. This is how democracy works. The people get to elect their elected leaders. And the people elected me because they trust my judgment, they share my vision, and they've seen the success that we've had in keeping Hillsborough County one of the safest counties in the state of Florida.
To be clear, you were elected twice in Hillsborough County. The voters twice elected you. Now, whatever happens in court, this could also go to the Florida State Senate. Do you think that the Florida State Senate would uphold your appeal to them?
Well, the Florida State Senate has a role to play, but only in a situation where the governor's suspension is within the law. Here, the governor's suspension is clearly outside the law, so we don't expect it ever to get to the Senate.
All right, Andrew Warren, thank you so much for joining us this morning. Appreciate it.
Thanks so much for having me.